You found out that a competitor is selling or producing your patented product. In this video, you found out how you can maximize your chances in patent infringement cases against your competitors. First of all, I want to give you some statistics. So in Europe, there are around 2,000 patent infringement cases every year, and 1,200 of them are in Germany. For comparison, the UK has around 50 patent infringement cases every year, and France and Italy between 250 and 300. And there are actually 14 countries in the EU where there are no patent infringement cases at all. So Germany takes up most of the patent infringement cases in Europe, and of the German courts, Düsseldorf is the largest player at the moment, with around 500 to 600 cases every year. If you want to find out more about the statistics of patent infringement, I wrote an article recently which I can send you if you want to. Just leave me a comment under the video or send me an email. I have my contact information below that video. So you start, of course, with collecting evidence. The biggest difference to the UK and France and the US is that you have limited discovery abilities. If you have a method or process claim, you can ask a court for a preliminary injunction with the aim to inspect the process or the method of a potential infringer, but you cannot do that by yourself or by your attorneys. You have to send an independent court expert, and you have to give the court expert some homework. What exactly to look for. So for example, to press buttons on different machines, or to look at the recipes, or to have a USB stick inserted into computers and copying the relevant files for the method or process. So it's quite limited, and you have to make sure that you are aware of this. In some instances, you can use discovery material, so discovered material from other countries. So if you have already done some discovery in, let's say, the UK or in France or in the US, you can, in some cases, use that evidence in Germany as well. Typically, first you want to send a cease and desist letter. You do that to avoid cost risk. You have to know that in Germany, the loser pays all. So if you lose your case, then you have to pay the attorney and court fees, also of the other party. So to avoid that, you should file a cease and desist letter first, because even if you win, and the potential infringer says in court, they didn't warn me. If they had warned me, I would have immediately stopped. Then you get a positive decision by the court, but you have to bear all the costs of the procedure. And to avoid that, you would have to file a cease and desist letter first. You can set a quite short time frame, like 1 week, which is appropriate for patent cases, probably the shortest fair period that you can do. Sometimes I also use 2 weeks, but to be more fair, but 1 week is probably the shortest in patent cases, because patent cases are quite complicated cases. So if you want to stop somebody immediately, you can do something that is particular to Germany. You can file a request for preliminary injunction. Typically that's used with designs or trademarks, but that works for patents as well. Sometimes they are granted. You have to understand that a preliminary injunction means that you file a request with a court, and within sometimes 1 day, 2 days or 3 days, the court decides that the potential infringer has to stop selling, producing or offering the product in Germany immediately. So that is a quite sword that you can use, a weapon. And if you are wrong, you have to pay a lot of damages. So you have to really be careful whether you want to use this weapon. Also, It's difficult to convince the courts since patent cases are quite complicated and also the validity of the patent is not always clear. Some courts are granting preliminary injunctions, for example Munich, but also other courts like Düsseldorf and Hamburg and Mannheim. So you can try. You cannot be sure that you get this granted, at least not with oral proceedings, hearing the other party. Then preparing the complaint is quite probably similar to the other legislations. When I became a patent attorney a long time ago, I did an internship with the judges in Düsseldorf, the patent judges. And I found out how they deal with patent infringement cases, how they assess patent infringement. And one tool they use is they mark the claim with colors, the features in the claim with colors, and then they get a depiction, an image of the infringing product and mark the corresponding features in the infringing product with the corresponding color of the claim. To understand whether something is infringed or not. So if you can provide this to the judges with the complaint, that probably helps your case because you can of course use the colors as you would like the judges to use the colors. So you can basically mark the features in the infringing product the way you would like the judges to interpret the claim. I have an example in the video as you can see it. Then last but not least, it's important to know where you want to file your complaint. Each state in Germany has defined 1 or 2 courts where you can file patent infringement complaints. And I already mentioned that only a couple of courts have lots of experience, for example Düsseldorf and Munich and Mannheim and Hamburg. And the other courts do not really have a lot patent infringement cases. On the other hand, you have to know that the larger, more important courts, as I mentioned, also have a quite quick turnaround. Typically you get your first instance ruling within 1 year and the second instance ruling within another year. If you have more questions about patent infringement in Germany, you can write an email to me. My contact details are below this video. You can post a comment, of course, below this video. You can like the video if you like the video. You can subscribe to my channel and most importantly, protect your intellectual property and go make it count.